I've interviewed thousands of people, from serial killers to ministers. Welcome to the interview room. Good afternoon, everybody. On this Monday, special TIR, a bonus episode. So grateful that you're able to make it. We'll give it a couple of minutes, let folks know that the notification is going off. Hopefully you had a great Sunday evening. And if you haven't had a chance to go watch the program we did last night, I think we were on target. And today I'm hoping, as we go over the new information provided by the court, the ruling, and the motion to change a venue, I'm going to be interested in what you are all thinking. And if you haven't had an opportunity yet to make it to your nearest bookstore, make sure you get out there, because apparently Scott Green has a book signing. And you don't want to miss that, especially with today's ruling, now that everything is leaving his community. If you did miss it, it was yesterday at 11 a.m., 12:30 to 12:30. Isn't that convenient? He's having a book signing. And of course, nothing to see here. Move along. Meet and greet. A book signing with President Green in Coeur d'Alene. That was yesterday. Well, we're talking about 4 victims on his college, or actually outside of the college. He's signing books. Amazing, amazing, amazing. Well, I hope you had a great evening last night, hanging out here with TIR. We've got a lot of great information for you tonight. We're going to cover this most recent release from the court. As predicted, we were thinking, if the judge is going to make a decision, he's got to make it and get it over with, because that was a good thing that he did make a decision. I find it really interesting, though, the decision that he did make. If this is your first time here, we hope you will hit the subscribe button and hit the like button. And that you will share this with each and every one of your friends and on your social media networks. And of course, this channel is always victim focused, remembering Ethan, Maddie, Kaylee, and Xana. Just on this, in this particular case here, I cannot imagine what mom and dad for each of these 4 victims is going through today. And I have a question for you. I have a question for Latah County and the jurors there. Do you realize the court just slapped you in the face? Each and every one of you. So, you know, the only thing I could think of when I read this thing, and the fact that it came out after last night, this morning, that it hit, I thought to myself, wait a minute. He made his decision a while ago. And the 20-page decision that he made, he pushes it out. And it was interesting that while he's telling the world, we're going to move this thing, you have the university president having a book signing. And I thought to myself, okay, well, this can't be by coincidence. This just can't be by coincidence. In fact, I thought, you know what? I've seen this before.
What is your name?
Gail Tempest.
What is your occupation?
I'm a dancer.
On the night of February the 13th, were you working at the Black Bottom Cafe when this murder was committed?
Yes, but I didn't do it.
Then who killed Kirk Robin?
I don't know.
Didn't you kill Kirk Robin?
I object, Your Honor, and ask that the last question be stricken from the records. It is merely an attempt to influence this intelligent, broad-minded, and most intellectual jury.
And I thought to myself, you know, I've seen juries like this, or I've read things like this, and I thought, no, that can't be a coincidence, right? The old coinky-dink. And then, you know, I read what the family responded on their Facebook page this morning. I read their Twitter feed. And my heart just broke. It's like, holy cow. And then I read every word of this change of venue motion. And I tried to, and I'm continuing to try to be objective in relationship to, you know, how things go, right? The rules. I am hoping that the Attorney General's office in the state of Idaho will step in and take this madness so that justice can be had for these 4 victims and their families. It is obvious. What if I told you that the University of Idaho influenced the decision to get this trial out of Moscow? What if I told you the University of Idaho influenced the decision to tear down the crime scene. What if I told you the University of Idaho was in partnership with the court? What if I showed you that one of the things the judge cited in this ruling, remember, the court's job is to remain neutral. We talked about this last night about Lady Justice. But I want to point out a sentence that the judge utilized on page 2 of the ruling. Quote, and I'm going to read it. Throughout the course of the investigation, the Moscow Police Department, in partnership with the University of Idaho, the Latah County Prosecutor's Office, and the Idaho State Police held press briefings to answer questions and reassure the public. Okay. I have said from the very beginning, there is much more going on behind the scenes. Now that this judge has severed himself from this case, he has admitted on paper from the very beginning, throughout the course of the investigation, that the police department was working in partnership with the University of Idaho. Now, I have said that is a huge conflict of interest in a high-profile murder case. And when we read it in Scott's book, Green's book, that his management team, and he wrote a whole chapter about it, was involved in many of the conversations. Folks, Ann Taylor's not done. I'm gonna say again that she's gotten everything she wants. And I think this is another win for the defense. But I believe that behind the scenes, the reason she's getting some of this stuff like this, and the judge was not stopping it, was because of this sentence, one of them, in this document. Because even the judge came to the realization that a police department's not supposed to be in partnership with a university while investigating one of the largest, if not the most profound, murders in this country. And he had to put it on paper because that's what his conscience told him to do, and that was the right thing to do. But here we learn that he uses this as justification to his ruling, towards his ruling, that they were controlling the flow of information. But what's critical here is the sequence that he highlighted. And the sequence is that he says, as law enforcement investigated, news stations, newspapers, and social media were flooded with stories of speculation about the homicides. Throughout the course of the investigation, the Moscow Police Department, in partnership with the University of Idaho, the Latah County Prosecutor's Office, and the Idaho State Police, held press briefings to answer questions and reassure the public. Appropriately, the information released was limited to protect the integrity of the ongoing investigation. Do you realize what I don't even know if he realizes what he just said. What he just said was the university participated with 3 other law enforcement agencies, i.e. the prosecutor's office, Idaho State Police, and Moscow State Police, in crafting the messaging to the public. And when you think about that, okay, the only connection to the university are these 4 students who paid tuition to the university. The homicides occurred off campus, and the house was not owned by the university. It was later gifted to the university. But what Judge Judd just did was tell the world from the very beginning, these 2 have been in cahoots. Law enforcement and the university created a partnership early on. And then you can back that up in Scott Green's book, in his chapters on how to manage a crisis. And so what happened there, when that happened, I started to think this whole motion's going to be about emotion. It's going to be about feelings, not fact. And let me give just a simple example on what I mean by that. This little thing that I got up here is how the media used to cover crime and still does in the world, in the United States. Right? I'm not bashing law enforcement. I'm bashing the U of I because the judge said they had a partnership. If you have evidence otherwise, put it in the chat and I'll put it up. This is how crime was covered in the 30s, the 40s, the 50s, the 60s, the 70s, the 80s, the 90s. Okay. All of these crimes have always been covered by the media. every single one of them, thousands of them, have always been covered by the media. In fact, they have perp walks even to this day in the United States. Perp walks, think about that. Okay? Where the suspect is walked out in front of the public. Look at all of these tens of thousands of crimes. What makes Bryan Kohberger any more special than all of these people? You know what's different is the emotion of the community and the lack of common sense in the courtroom. Because I'm going to read what the judge said. And I'm going to question it. Because the decision that he made, okay, was based on emotion. And Anya, I hope you come back when Dr. B is here. And if you're not, that's okay. Have a good day. Go to bed. By the way, everybody, I'm not here for me. So I'm good if people, but if you come into my chat and just want to criticize, that's your problem. It's not mine, but I'll call you out. I'll guarantee it. Because I don't think you have the courage to step up and know what I know. You're a coward. That's why you come into chats. I'm here for the family. I'm not here for cowards. And I'm not here for Bryan Kohberger. And I'm not here for the judge. I'm here to tell the truth. I'm here to say, hey, I have a question. Why in the world would a judge in the background section of this say that there was an agreement between the university and the police department? Why is that? See, you trolls can't come up with that, can you? No, because you're trolls. That's what you do. You're sitting in your basement. You're eating your bombs. And in the afternoon, you decide, oh, here's something. I'll just jump on this. And all you do is strike out because you yourself hate yourself. And you need to look in the mirror and realize that. I'm sorry that you feel that way about yourself. You absolutely loathe your psychosis. Remember, my background was criminal behavior analysis. I sit with criminals every single day, and I see trolls like you every moment of my 8-hour work shift. So welcome. Welcome aboard. Throughout the course of this investigation, the Moscow Police Department, in partnership with the University of Idaho, the Latah County Prosecutor's Office, and the Idaho State Police, held press briefings to answer questions and reassure the public. Appropriately, the information released was limited to protecting the integrity of the ongoing investigation. On December 30, 2022, Kohberger was arrested and charged with 4 counts of murder in first degree and 1 count of burglary. The 1 count of burglary was the aggravating circumstance. And that is what that's what Ann is taking on. Again, media outlets descended upon Moscow, and news coverage quickly focused on Kohberger. Yep. The same day, an order governing courthouse and courtroom conduct was entered to help alleviate any potentially prejudicial photography, audio, or video recording, and interviews within the courthouse. Call coming in, Your Honor. It's been going on for 70, 80 years. Bryan Kohberger's not special. Not special at all. I sniffed this out a long time ago that you guys over there were just worried about emotions. You weren't thinking about the victim. All you were worried about is how do we look in this situation? The university circled the wagons. The law enforcement agencies jumped on board. Shame on that chief. Shame on that chief. It shouldn't have happened. You should have not let that house disappear, because now, I'm going to say it for the 500th time, now that that house is gone, and now that this case is going to another county, they're going to want to see it. They're going to want to see it. The only thing I'm praying for this family is that they get also a new prosecutor on this thing, because he sat there like a wet blanket and let the defense run all over him, all over them. And the judge even points it out. Because of the extensive media coverage from the onset of the homicide, a non-dissemination order was quickly put into place by stipulation of the parties on January 3rd to help protect Kohberger's right to a fair trial by an impartial jury. The non-dissemination order, as amended, has remained in place throughout the duration of this case, i.e., you can't say anything, family. You're not allowed to. But Ann, if you want to write all of these motions and project your information out into the public, feel free. Oh, and then, by the way, Ann, you can use it in your change of venue motion and your argument before the court. And then the court can regurgitate it backwards to the public in this motion. In addition to efforts, in an additional effort to help protect Kohberger's right to a fair trial, on November 17th, this court entered an order removing cameras from the courtroom. Since that time, the proceedings have been streamed via the court's YouTube channel, which in theory, so he thinks it's a theory, allows the public access to the proceedings while minimizing prejudicial photographs and videos focusing solely on Kohberger and his every move. I don't know if anybody told them over there, okay, that when Kohberger was being brought from the van to the courthouse, people were yelling, "Did you do it? Did you do it, Bryan? Why'd you kill him?" You know, kind of like they did with all of these people up here. You know, all of these suspects, whoever they are, every single one of them. Every one of these people had the same problem that Bryan Kohberger did in Latah County. So, additionally, and perhaps more challenging, is the ongoing spread of prejudicial misinformation, rumors, and patently false theories of the case on social media outlets such as Facebook, podcasts, and blogs. It's called the First Amendment. Not to break it up in Idaho, but, you know, your AG shouldn't, you know, he's a good guy and he knows what the First Amendment is. Okay. Oh, it's the university that wanted to control the flow of information, kind of like their volleyball coach who was abusing their team. That guy. Oh, the one you guys just let go. And by the way, I reached out this morning for a comment from the university about their participation in this. You're not going to believe it. No comment. They refused. But just to remind you, Scott was at a book signing yesterday. Maybe somebody needs to ask him at his book signing. Because apparently the victims got lost in this somewhere. The victims got lost. Maddie got lost. Ethan got lost. Xana got lost. All four of Kaylee got lost. They got lost in this. And that's not what our system is designed to do. Our system is designed to bring justice, not only for the victims, but for Bryan. And the moment the victims got lost in this, I think if you were to go back over the last year, the court really didn't focus on the victims. The court only focused on perception, emotion, and false theories. Well, the whole reason, and that's just pure inexperience. That's what that is. He's had this case for quite a long time. And if he felt he was not capable of pulling this off in that county, early on, he should have excused himself, recused himself, and kicked this out early so that the family can get on with it. But what he has done now is punted. He has punted this case down the road and not even told the family what that means yet. Again, he's worried about the challenges of ongoing spread of prejudicial misinformation, rumors, and false theories. There has also been numerous television shows, documentaries produced about the homicides, and at least one book, no, two books. Blum's book and your professor's book, the university's president's book, excuse me. Two books, Your Honor. It's just convenient that you forgot that one. Remember the partnership with the police department, the University of Idaho? That guy's book. The one that yesterday he was book signing, Meet the President. Okay. You forgot that book. If you read between the lines on these things, it is very clear that they are still controlling the narrative. And what they have successfully done now is they got rid of the mass murder of 4 students at the University of Idaho. They have taken those 4 students and said, get out of town and take Bryan with you. That is disgusting. Because the parties agree the case has generated extensive coverage by the media, internet sleuths, and others trying to capitalize on the tragedy. You mean like your president at the university? Writing a book and a whole chapter on the murders? That guy? Is that who you're talking about here? but disagree on how the court should attempt to remedy the issue to ensure Kohberger is tried by a fair, impartial jury. Well, impanel the jury through the voir dire process. And he goes on to talk about it, and we'll get there. In sum, Kohberger argues the venue must be changed from Latah County to a location with a larger population that is geographically distant from where the homicides occurred. The argument, make it go away. Make it go away. If it goes to Boise, all these people won't be driving by the university when they're going to the court. Maybe they'll go by Boise State instead and think, oh, well, maybe it was over there. I'm being facetious, of course. The state asserts that a larger jury pool, extensive jury questionnaires, and voir dire are sufficient remedies that will result in a fair and impartial jury in Latah County. And the state was correct. And he goes on to talk about emotion. All emotion. And then he brings in the witnesses' testimonies of all the defense witnesses who were doing their job. They just did their thing. But one of them in here was really interesting. Let's see here. Let me go up to page 3. I got to show you this. I highlighted this one right here. Since that time, the proceedings have been streamed via the court's YouTube channel, which in theory allows the public access to proceedings while minimizing prejudicial photographs and videos, focusing solely on Kohberger and his every move. Well, that's the media's job. That's what the media is supposed to do, is focus on Kohberger because he's the only guy in custody. Radio stations, television news outlets has continued throughout the state and nationally. Well, you're right, Your Honor. So how is changing the venue going to change that? I don't see that happening. Does anybody else see that happening? There has also been numerous television shows and documentaries, and of course the one book that he mentioned. And then he ties it into, a fair trial, and that the prosecution said, "Hey, Your Honor, we can sort through this through the voir dire process. It shouldn't be an issue. We can cut right through it. Okay, we can cut right through it." And then he talks about this. He lets the 4 witnesses, or excuse me, the 3 experts talk about the results of their, surveys. So let's go to the courthouse in Latah County.
Objection sustained.
Thank you, Your Honor. No. Prepare yourself for the witness box.
That's what it felt like when I read this thing. It was like, you got to be kidding me. That, and I hate to say it, I've been saying this for over a year, that this judge was out of his league. He should have stuck to juvenile court, because towards the end of this, he starts talking about all of the problems in Latah County. You can't make this stuff up. Okay? You can't make this stuff up. Next, the extensive negative publicity. So this is from one of the experts. Surrounding Kohberger leads potential jurors to think of Kohberger negatively. All right, well, here is a call coming in. Every one of these guys, when people see them, say, guess, and look, there he is right there. There's Bryan in the middle. But look how many other people he's surrounded by. Okay. Look how many other people he's surrounded by just when you type in true crime. He's not the only one, Latah County. You know, judge. He's not the only one. You know, it's just the fact that you've never experienced anything like this in this county. Okay. That's the problem. Because look what you let one of the experts testify. Now, after Kohberger's name and picture have been associated with terms like murderer, evil, killer, and stalker, when individuals hear that name, there's a negative association. Okay, I'm going to give you a little run here. Okay. Ted Bundy. How did that hit you? Karen Reed. How'd that hit the audience? Right? I could go on. You guys get the point. When individuals hear that name, there's a negative association. This impact is greater in Latah County because of the saturation of the extensive media coverage. What, the local newspaper? Finally, then they give this doctor more room. Then Brian Edelman comes in with his surveys, 67%. I'm here to tell you, changing the venue, it's not going to make a difference. The good news that comes out of this is the judge is gone. The bad news that comes out of this, okay, is that now if this goes to another county, that house becomes critical. Critical, because folks may want to go back to the crime scene. There was one part in here where part of the testimony was, well, when you hear the name in Latah County, they automatically assume Kohberger's guilty. I mean, good grief. I just had people in the chat over here saying Bryan's innocent. I get comments all the time. Bryan Kohberger didn't do this. He's being framed. Okay, that's good. You have an opinion. They have an opinion. But apparently the court couldn't see that people have difference of an opinion. I hope they do call me. If they want to call me, not a problem. I testify all the time. I just testified recently in a homicide in Virginia. Not an issue. I'll put my hand up and I tell the truth. 1,000%. 1,000%. I've been down that road more than once. I got caught up in a case in California where people think I arrested the 3 boys for committing a crime. It's all over YouTube. People say it all the time. It's all over the place. Okay. But when they look at it and when they do their research, I was the only investigator that said the guy they had in custody was not the guy. And they took him to trial, not guilty. Asked me if I testified. Right? No, because they knew I was going to tell the truth. So bring it on. Bring them in. but I'm gonna defend the victims. And if there's exculpatory evidence that will, in my opinion, bring Mr. Kohberger out of the circle, I'll tell him that too. This appears to be, nothing here, nothing to see here. But he has to prove why his phone pinged in that neighborhood 12 separate times. He's the one that has to show why his DNA is on that snap. He has to show why he was cleaning his car with his gloves and putting his trash in his neighbors' houses. He has to do all of that. And what the judge did here in this, number 5, defense has also submitted numerous media articles and video clips demonstrating the sheer volume of coverage this case has generated. Remember in that gag order, they're not to talk to the media or whatever, okay? But apparently the defense has been collecting all of this. She's come in with motions, stirred the pot, got people talking, except for the family, and then they collect it and they put it into a motion and they use it against the victims. They use it against all 4 of the victims: Ethan, Maddie, Kaylee, Zanum. Knowledge is power. And by shutting down the flow of information to the public, it created this whole other conversation that took place, about this guy did that and the tunnels under the house and, all kinds of stuff that blew up. Okay. But by golly, the family can't say anything. Don't you dare. While some of the mainstream reporting has been appropriate, since when does the court decide what reporting is appropriate under the First Amendment? Just because you don't like something doesn't make it appropriate or inappropriate. If CNN or if MSNBC or Fox or anybody else or any experienced commentator or journalist says something you don't like, you get to determine if it's appropriate and based on information from the court record. Well, what if they have sources? Here's something that's inappropriate. A couple of days ago, it was reported on social media that this decision was coming. Who leaked that from the courthouse? Is this another, Becky problem for Murdoch? Is the defense leaking information through triangulation, and now all of a sudden it hits the media, and then they come back and they go, Your Honor, this stuff is out there. It happens. It happens. Based on information from the court record, there has been extensive coverage that is prejudicial to Kohberger and likely inadmissible at trial. Well, no kidding. That's your job, Your Honor, to say that's not coming in. Next issue. But you sat on this for so long, you had no chutzpah to stop it and to put people in check and move them, and just say that let's keep moving. Let's move this case. Keep moving. So now you cite, the criminal rules. Okay, right. Idaho criminal rules, the standards, the Constitution of the Idaho, blah, blah, blah. Okay. What are the rule? 21A states that on motion of either party, the court must transfer the proceeding to another county if the court is satisfied that a fair and impartial jury cannot be had in the county where the case is pending. Well, how do you know yet? You haven't even impaneled anybody to ask them, have you ever seen this guy? Have you ever heard of this guy? Do you know anything about the case? So what's his analysis? The prejudicial argument from the defense. He comes up and the judge says, no, I don't know about that. Okay. The actual prejudice, though, he says, is in evaluating actual juror prejudice, the relevant question is not whether the community remembered the case, but whether the jurors at trial had such fixed options that they would not judge impartially the guilt of the defendant. Stated differently, courts must evaluate whether in the totality of the existing circumstances, jurors exposed to pretrial publicity resulted in a trial that was not fundamentally fair. The defendant bears the burden of proving prejudice or showing a reasonable likelihood there would be a prejudice. So now he goes on, okay? And so he says, while attempting to seat a jury, there is no real evidence, such as juror screening questionnaires and testimony during voir dire, for this court to evaluate actual prejudice. So what he's saying is, yeah, this is one standard that I could use to kick this to a change of venue. Okay, but we haven't even seated a panel to ask them, so that doesn't really apply. Okay? But then he goes to touchy-feely, okay, emotions. Okay, emotions. Adverse meaning presumed prejudice, meaning I think there's a prejudice, but it's a presumption. Not really sure. There could be. Okay. There could be. There could be the Easter Bunny. But I'm not positive. You know, it could be. Adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors claim that they can be impartial should not be believed. So basically what he just said here, starting off citing Patton versus Yount, is, you know, just because somebody's sitting over there, they could be lying. They could be lying. However, a presumption of prejudice attends only the extreme case, and juror exposure to news accounts of the crime alone do not presumptively deprive the defendant of due process. That's the counterpoint, the law, Skillings. And in parentheses, publicity by itself does not require a change of venue. Indeed, prominence does not necessarily produce prejudice, and juror impartiality does not require ignorance. Meaning, you know what? Juror number 42, yeah. Have you heard of Bryan? Yeah, well, yeah. And have you read anything? Well, you know, I saw the news, or, you know, I saw, you know, Nancy Grace, or, you know, Court TV with Vinny, you know, two great people. I love them both. Okay. Well, does that change your opinion? No. I can be impartial. Unlike with actual prejudice, where somebody says, no, this dude's guilty, man. That guy's down. He's down for the count. Unlike with actual prejudice, a finding of presumed prejudice means that the court need not consider juror screening questionnaires or testimony during voir dire before declaring a jury verdict void, or in this case, declaring a change of venue appropriate based on prejudice. So now this is where he's laying out his reasoning. I would call this the spineless decision. And it's probably a blessing to the family, because if this guy can't make this decision, can you imagine what a trial is going to be like if he was sitting at the bench? Okay. It's because it goes on here. It goes on here. Let's see here. It is the defendant's burden to establish a reasonable likelihood prejudicial news coverage prevented or will prevent a fair trial in violation of the Sixth Amendment to the United States Constitution. This is not an unreasonably high hurdle for a defendant to clear. And what he's saying there, what he was hinting there is, in this kind of situation, it's not really that hard. In cases where juror prejudice has been presumed, the following factors have been examined. 1, the size and characteristics of the community in which the crime occurred. So what he did is he fit it into the surveys. 2, whether news stories contained a confession or other blatantly prejudicial information of the type readers or viewers could not reasonably be expected to shut from sight, i.e. the conspiracy theories that the cops are involved, that they planted all the evidence, that there's tunnels underneath the house, all of that stuff that is all bogus, that stuff, Your Honor. Oh, number 3, the lapse of time between the prejudicial news coverage and the trial. Your Honor, we need a continuance. And even in the most recent venue argument, the change of venue, she argued 10 months isn't enough time. It's just not enough time, Your Honor. Okay. What the jury actually found as far as guilt is concerned, i.e. was the defendant acquitted of some charges. Well, he hasn't even been convicted. The extent of affidavits indicating prejudice or absent of prejudice in the community where the trial took place, blah, blah, blah. And here's his answer, or here's one of the answers here. When reviewing the nature and content of the pretrial publicity, the trial court should be concerned with the accuracy of the pretrial publicity, the extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence, and the number of articles and whether the jurors were so incessantly exposed to such articles that they had sublimely become conditioned to accept a particular version of the facts at trial. Meaning, if there was so much publicity pounded into the community that people actually came into the trial and said, there's tunnels under that house. How do you know that? Because it was in the news, and I've watched a ton of YouTube channels, and there's a lot of tunnels under that house. I know there are. And so I don't think Bryan came in through the tunnel. That's what they're arguing. That's what he was saying. That's what that law, Hayden, is saying. And so then they support it with the doctor saying, yeah, that's what it means. Okay. That's what it means. And so then we get down toward the bottom here. While the issue is extensive, sensationalized coverage is not unique to Latah County. It is potentially more impactful given the volume of coverage coupled with the smaller population. As to the lapse of time between the coverage of the trial and information provided by Mr. Murphy demonstrates that coverage has overall waned since February 23. However, there is an uptick in coverage before and after court hearings and decisions. This is especially true for Latah County, with Ada County following a similar trajectory. The court does not anticipate this trend will change leading up the trial and anticipates the coverage will substantially increase in the weeks before and days after the trial. Yeah. There are 4 dead students here. And then he goes, considering the undisputed evidence presented by the defense, the extreme nature of the news coverage in this case. So it's an information problem. It's a flow of information problem. Considering the indisputed evidence presented by the defense, the extreme nature of the news coverage in this case, and the smaller population in Latah County, the defense has met the rather low standard of demonstrating a reasonable likelihood that prejudicial news coverage will compromise a fair trial in Latah County. Thus, the court will grant Kohberger's motion to change venue for presumed prejudice. Do you see what he just did? This is the crux of these 20 pages on page 16. What he just said was, there's a lot of coverage out there on this case, including a book by his president of his university. And because of that, that's a very low bar that the defense had to jump over. And so there would be a reasonable likelihood that prejudicial news coverage will compromise a fair trial in Latah County. You see what he just did? He blamed the information. He blamed people, the First Amendment, for Bryan Kohberger not being able to get a fair trial in Latah County. But what's interesting is he started the whole conversation with the university, the police, and everybody working hand in hand to control the flow of information. So what he didn't address here was that they controlled the flow of information they wanted to. But they couldn't control the public and the narrative they wanted to project. So therefore, he grants a motion to move this thing. And then he gives us argument here about convenience of interest of justice, i.e., for the convenience of parties and witnesses. But then he starts to throw Latah County underneath the bus. He absolutely starts to throw the sheriff's department under the bus. Let's look what he talks about. I'm not throwing the cops under the bus. The judge is. Look here. While similarly addressed by the parties, the court has considered the logistics while the motion for change of venue was pending. So while Latah County court staff and court security are ready and willing to facilitate this trial to the best of their ability, there are serious issues that cannot be resolved no matter how much planning and preparation is done. This judge has known this from the beginning. And it's not fair to the family. It's not fair to the family. First, and perhaps most important, it is the issue of safety and security for the parties, witnesses, victims, families, jurors, and Latah community. The Latah County Sheriff's Office, which is currently fully staffed, simply lacks the number of officers needed to provide security for the trial while also continuing to perform their day-to-day duties of patrol and responding to calls. Well, then what the heck have you been doing for a year and a half, knowing that when you get to trial, this was your opinion in the very beginning? What is going on with these folks out there? What he just said was, yeah, they're ready, kind of, but let's be honest. If this trial takes place here, we don't have the officers to cover this. Why didn't he just tell the family that? This will play out in the future, not necessarily from the defense, but quite frankly, if the family takes other actions. Because this is a thought process that this judge had sitting there on the bench. When the first change of venue argument even came up, he could have said, you know what, counselor, I agree with you. Like whatever it was, whenever the very first one was, I agree with you, counselor. Okay, I'll have my decision tomorrow. Because it gets worse. And respond to calls. One solution is to ask the Idaho State Police and the Moscow State Police Department to help. However, officers from both ISP and MPD were heavily involved with investigating the homicides, and it's anticipated that several officers will be called to testify at trial. Well, what about all the officers that volunteered all their time to come to the university and go sledding? And you got $1 million. The university got $1 million from the governor's office to pay for that, to go sledding with the students because they were, they needed somebody to go sledding with. Well, and now he uses this argument that, well, there's just not enough resources. So when the homicides went down, you had all the resources in the world. In fact, the governor said, here's $1 million. In case you need more, let me know. And now you're saying in this motion, in all honesty, find the cup. Oh, wait, let's go back to the courthouse in Latah County.
Take off your hat. Now raise your right hand. Now place your left hand here.
Take off your hat.
Raise your right hand. Now put your left hand here.
Please take off your hat.
Raise your right hand. Now put your left hand here.
Will you please take off your hat?
Raise your right hand.
Sounds like a bunch of double talk to me. And that's what I saw. We're just reading it here together. And he goes, and anticipates several officers will be called to testify. Well, yeah, duh. Additionally, it's the court's understanding that both of these agencies are currently understaffed. Pulling local officer away from their normal duties for 3 months to provide trial security would potentially put Latah community at risk. And this is one of my favorites of this particular ruling. Further, in the event of a natural disaster, so basically what he's going to guess now, he's going to guess. Okay, the court's going to say, just in case, such as a wildfire or a large emergency, like an active shooter or multiple vehicle wreck. So I guess multiple vehicle wrecks, everybody runs out of the courtroom and responds to them. Okay. I mean, you can't make this stuff up. Here's a hint, Your Honor. They call that mutual aid. Okay. Just like when this thing went down, when the 4 victims were murdered, all of a sudden you had hundreds of law enforcement officers. In fact, Scott Green put it in his book. He had hundreds and hundreds of volunteers, officers showing up out of nowhere. out of nowhere. They volunteered their time. They had a list. They signed up. And here's one for you, Your Honor. I was actually in Idaho when this thing went down. And I was working with an agency up there in Fruitland. Look me up. I was helping them in the Michael Vaughn disappearance. That's why I was in Idaho. And guess what? The ISP guys we were working with left. And they went to this particular case. And that's how on Thanksgiving Day, I came up there right behind them. And he says here, active shooter, multiple vehicle wreck. There is a very real possibility that officers tasked with trial security would be pulled away to deal with other issues. Thus, while our local law enforcement is ready and willing to do what they need to do to ensure a safe trial, there are not enough officers to ensure the safety of the parties, witnesses, victims, families, jurors, and community for a 3-month period. All right, Latah County, there you go. You've got officers, okay, for, I guess, 24 hours at a time. Okay, 24 hours at a time. They definitely can't do things for 3 months, according to the court. And now we go into the courthouse. And by the way, I think what's interesting about this is the judge actually put this on paper, knowing, I mean, he had to reflect back and come up with reasons for the argument that was given by the defense. And then he had to fit his rationale into the reasoning in this motion and this decision. Okay. And in this decision, he had to rationalize that, look, there's just not enough cops. If we had the trial here, there just wouldn't be enough cops. Well, what was he thinking when the families were saying, are you guys good with this? Can you guys pull this off? There, is it all good? And the state going, oh yeah, we got it. Don't worry about it. Okay. I find it fascinating that the state sat there and said nothing. And said nothing. I really hope the Attorney General's office steps in and the state says, you know what? Here, you do this. It's over our head. Because I think if that happens, the family, there's a very large plus sign that the family will get justice and they deserve justice. Because now the judge puts in part of his reasoning here is they don't have enough clerks in the court. Okay. Says, similarly, Latah County does not have enough court clerks to efficiently manage the jury selection process. They can't even manage a jury selection process? Oh my goodness. It is anticipated that general qualification questions will need to be sent out to some 6,000 individuals. The court clerk will be tasked with then entering juror information from those 6,000 individuals into an electronic system. This task alone will require several clerks and will take time. Latah County has only one court clerk currently familiar with the process, and she has several other day-to-day responsibilities outside of her role as jury commissioner. Thus, to accomplish this task, Latah County would have to bring in clerks from other counties to help, along with extra computer equipment for those clerks to perform their work. Is that a problem in Latah County? Is that an issue? Do the victims qualify for extra clerks? Extra police? Did they qualify, Your Honor? Or maybe the partnership with the university was much more important. Asking for the families of Ethan, Maddie, Kaylee, and Xana. Just asking around. After the initial process, the court would summons in some 1,800 individuals to fill out extensive juror questionnaires. What blows my mind is the epiphany of, didn't he know where he works? Didn't he know his staffing levels? Didn't he know that there would be a shortage of everything according to what he's, giving as a rationalization? Again, this process would require both court clerks and court security to take attendance, manage and move the individuals where they need to go to fill out questionnaires in privacy, scan questionnaires, and quickly get the questionnaires to court and counsel. Well, just out of curiosity, how do you guys manage this fire that they would have to run to if it was a natural disaster? What do you guys do up there when there's a huge fire? What does Latah County do? They call the university, they circle up the wagons, and they say, okay, we got a fire. Yeah, okay, well, it doesn't affect us, so we're good. Okay. I mean, this just doesn't seem like it's working correctly here in my mind. I don't know. What do you guys think? I mean, I'm reading this stuff right from the judge's mouth, i.e. onto paper. Again, while Latah County court staff are willing to do what needs to be done, i.e. the feelings, the reality is that we do not have enough individuals to perform the task of jury selection efficiently and effectively. So what he just said was, you know what, in reality, because he says it right here, the reality is that we do not have enough individuals. Why didn't you tell the family this a year ago? Why did you wait to tell the family this and then create a motion that creates emotion for the family? And you stick it one more time to them in a holding pattern and kick it up to the Supreme Court in Idaho and say, you know what, I'm out. Oh, and by the way, I knew this, whenever I knew it, which apparently you work there. He works there. And there, thank goodness you did release it and let it go. Because again, I'm going to go back to maybe the family now has a chance of getting justice. Further, now he criticizes the courthouse. Taxpayers in Latah County, you need to tear that courthouse down and build another one that's big enough for murder trials. The Latah County Courthouse itself poses significant issues for a trial of this length, 3 months, and magnitude. The courthouse lacks the space needed by both state and the defense. Well, take some of that money that the university runs that town with and buy a new frickin' courthouse. Tear it down and rebuild it. You tore down the crime scene. It's the least you could do. Well, the state has a dedicated space within the courthouse. The state would still be faced with the challenge of escorting sensitive witnesses through public spaces in the courthouse to get to the courtroom. Meanwhile, the defense does not have a dedicated space within the courthouse, and there are limited options available. You know what? Name the courthouse after the 4 students. The new courthouse. Don't put another memorial up, which thank you for doing that, the university and the college students, for the families, to give them a place. But why don't you tear down that courthouse and put a new one up in the memory of these 4 students? And so that, God forbid, if you have another problem like this in the future, at least you have the space to try the individual arrested for the crime allegedly. Meanwhile, the defense does not have a dedicated space within the courthouse, and there are limited options available. The few options, the district court meeting room or pretrial room, are small, located in public areas, and are not soundproof. And that's important for the defense. I agree with you, with the judge here, 1,000%. These locations do not provide the defense with the privacy it needs during the trial to meet with each other and witnesses. Yeah, you mean when Ann dumps one client and runs to the next, okay, because it's a higher profile and she'll make $1 million? Yeah, she needs her own room. Further, the jury room itself is problematic in terms of size. Fitting 12 to 13 jurors in the jury room for a routine trial is crowded. Fitting 18 jurors in the jury room for 3 months would be uncomfortable at best. Additionally, the door between the jury room and courthouse is not soundproof. So the judge knows that he's been having defense counsel or the state having meetings in this other room, and that everybody can hear what's going on. That's what he just copped out to. Okay? Everybody knows that, the 2 rooms aren't soundproof. Further, the court security would be tasked with trying to bring the jury into the courthouse in a fashion that ensures the jury's privacy while also ensuring the court's privacy. The only option for bringing the jury into the courtroom is through the public hallway or directly past the court's chambers. Neither are good options. Yeah, this is like small town, hey, we're going to do this ourselves. But you know what? I can't help it but think that the University of Idaho had so much influence on this particular decision. Okay? I can't help it to think that behind the scenes, it was already in motion. And that the families, again, were neglected, just like the house. The families said, they came up and they said, no, don't do that, state. Don't do that. Please consider it. Please don't do that. And what does the university do? And it's in the documents. The university decides, hey, we're just going to tear it down after it was donated to them. So they reach out to Moscow PD and say, hey, we're going to tear the house down. You guys cool? Well, you need to ask the DA. Hey, you guys cool? We're knocking the house down. Well, yeah, we're cool. We got all the measurements. Okay. How about you, defense? He's like, yeah, make it go away. Please tear it down. Make it go away. Quick. Okay. And then they set into motion that the house is coming down. They don't tell the public. The university sets into motion to tear down probably one of the biggest high-profile murder cases in the United States, if not internationally. The university decides it's going away. And then all of a sudden, remember, like 6 months in, right? They wanted to hold it just for a little bit longer. All of a sudden, the FBI shows up with a FARO. Remember that? Okay. Let me refresh everybody's memory. This was the FBI agent showing up with the University of Idaho facilities team. And they took additional measurements. Remember, they were confident. And I said, there's a problem here. Now, all of a sudden, the facilities managers are in charge of the crime scene. That's a problem. So the university makes a decision. Yeah, tear it down. They got everything. And then the FBI steps in and says, whoa, wait a minute. We forgot some things. We got to come back. And they do. They go back. And now, okay, behind the scenes, I think, and this is just my opinion, I could be wrong, but based on Scott Green and his book signing, okay, yesterday, come meet Scott Green and his book, his book signing. You come on over to Coeur d'Alene. The president of the university is signing his book. And there's a whole chapter in there on how to manage a homicide at a university. I'll tell you all about it. Scott Green. Okay. And then the judge says here, oh, by the way, day-to-day operations of the district court and the juvenile CPS caseloads will have to continue. I.e., he's given excuses now why this can't happen. Okay. Further, there is also issue with the continuing day-to-day operations of the Latah County Courthouse. The magistrate judge will continue to have daily hearings. Yeah. A district judge will continue to have day-to-day operations of the district court. Mm-hmm. And the juvenile and CPS caseloads will have to continue. Correct. Additionally, the clerk's office must continue in its day-to-day operations of processing case files, taking payments, and assisting the public. Mm-hmm. All the normal court operations will undoubtedly be strained by the resources required for this trial in terms of space and personnel. Yeah. You have 4 dead people. It's called taxpayer money. It's called get hold of the governor and get more money if needed. Because justice has to be done for these 4 deceased students. That's what's getting lost here in this ridiculous change of venue document. This case is about them. It's not about the clerks. It's not about whether the air conditioning is working at the courthouse or if you have enough, printer, toner in the Xerox machine. It is about these 4 victims. I guess it is a huge blessing, I guess, for the family to think about. Okay. the fact that this guy will not be sitting on the bench to determine whether or not the individual in custody committed this crime and horrifically brutalized these 4 victims. He goes on to say, you know, if we just think about what the horrific crime scene is going to look like. Okay. I mean, I don't think we can wrap our minds around it. I have been through, you know, I've been to a lot of crime scenes. I've seen a lot of destruction. I've seen a lot of stuff. Okay. And I can tell you from personal experience, being there, seeing it, smelling it, feeling it, okay, that when you have a judge who says, well, traveling to another county for 3 months is indeed inconvenient for the attorneys. You see how he started this sentence? This is somebody out of touch. It should have said, while traveling to another county for 3 months is an inconvenience for family members of the victims, some witnesses, the attorneys, and the court. You come last. But not this case. It's selfish. And he wrote it here. He put it in writing. For 3 months, indeed, inconvenience for the attorneys who are getting paid. Ann's a millionaire now. The court himself. You know, I may have to go play, you know, pickleball. I don't want to miss my pickleball round. Some family members of the victims. Well, you can't mention all of the victims' families? All 4 of them? You have a favorite? You have a favorite victim? Family victim? Your Honor? Some family members of the victims? Would only a few family members are affected by this? Only a few family members will never have another birthday with their child. Only a few family members will never have another Christmas, another Easter, another Thanksgiving, a graduation, grandchildren, children. Only a few family members will be affected by that. Some witnesses. Having the trial in Latah County Courthouse would also be inconvenience in numerous ways, and beyond that would present serious safety risk. Well, then why didn't you say that over a year ago? What is the malfunction? Thus, the interest of justice requires, meaning Bryan, that the trial be moved to a venue with the resources, both in terms of personal space necessary to effectively and efficiently handle a trial of this magnitude and length, so that the parties in the court can focus on the case and not peripheral issues, i.e., like the feelings of everybody at the university. Kohberger's motion to change a venue is granted. This court orders a transfer of venue without specifying the new place of venue, i.e., I don't know how to make a decision. I analyze till I paralyze, and I drag it out as long as I can so that, you know, After it's all over, I get to tell you, hey, by the way, I've been thinking this for a very long time. Okay, we don't have the cops, we don't have the building, we don't have the offices, we don't have the resources, we don't have the clerks, we don't have none of this stuff. Okay, but here's a hint. A year and a half later, I can tell you there is a proper venue somewhere, but I don't know how to make that decision. So I'm going to ask the Supreme Court, okay, to make that decision. And just so you know, yeah, I got to go play pickleball. So I'm out. And the court orders a transfer of venue without specifying the new place of venue and refers the case to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue in another judicial district and assignment of a special judge to preside in the criminal proceedings. So he steps away. Which begs the question, that he started his whole motion. Page 2. 1, 2, 3, 4, 5. Or let's see here. Let me find it. Begs the question. The cause of death for each was ruled a homicide. As news of the tragedy broke, media outlets from around the country descended upon Moscow. As law enforcement investigated, these guys were just worried about their perception. As law enforcement investigated, news stations, newspapers, and social media were flooded with stories of speculation about the homicide. Throughout the course of the investigation, the Moscow Police Department, in partnership with the University of Idaho. That's crazy. That the police department partnered up, and it makes a lot more sense now that the university was calling all the shots. I think it was clear. I really do. I think it was clear.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Huh?
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Are you trying to give me the double talk?
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Why don't you answer him?
He's talking pig Latin. I don't know what he's saying.
He's asking you if you swear.
No, but I know all the words.
He's asking you if you'll swear to tell the truth.
Truth is stranger than fiction. Judgy Wudgy.
Kindly address this court as Your Honor and take the oath.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Certainly. What have I got to lose?
Take the stand.
That's what Ann's going to do next. Because as this has been changed now, there will be another bite at the apple. More delays, more delays, more delays. And don't be surprised if she doesn't do another survey in the next county with the next judge, where she's going to determine, Your Honor, let me tell you my story. You know, let me tell you this, let me tell you that. And the family is now not only financially going to be strapped, or others are of the family, you know, families, but she's going to turn up the volume. And to each and every one of you, we are so grateful. Karen and I are so grateful to each of you for being a part of this channel and supporting us. I'm so appreciative of, you know, getting to see each of you on Sundays, and then sometimes like this. I just, my heart just bleeds for the families, though, in these situations. It is really hard for the families to go through stuff like this. And the prosecution should step forward and say, you know what? Enough. Let's get this going. Let's move on. We're prepared for trial, Your Honor. Okay. 13 motions the defense filed. And the prosecution's like, well, we're ready. We're ready. Let's rock. Let's rock. Okay. Have they been ready? What do you guys think? Do you think they've been ready? The court obviously wasn't ready. He wrote it this morning and put it out there. The judge put it out there that, guess what? And we just read it. What he just did was the curly shuffle and showed everybody, you know what? We weren't ready. We're not ready. It was a facade. It was a facade. And so when you see and when we read stuff like this from the court, and then we think about, well, why in the world did they tear the house down? What was that all about? Why couldn't they wait? And now think about Latah County, wherever the Supreme Court's going to put it in Idaho, wherever they put this, okay? And you get one or two jurors, and I know I pounded a dead horse on this, but I really feel that it could be very dangerous, you know, because the family's going to be, you know, walking on eggshells if you just get one person to say, you know what? I want to see it. I want to go. I'd like to go, Your Honor. I'd like to go. You know, I'd like to see it. And at that point, you know, they're going to drive all the way over there. If they have a jury view, if this new judge comes in and says, hey, I haven't seen it. Yeah, I'd like to see it too. And the judge grants a jury view, and they get over there and it's a dirt lot. Oh my goodness. You know, what do you say? No. It wasn't a dirt lot. You've seen the video recreation of it. You've seen the inside of it. It's this. It was this. It was this. It was this. Okay. Well, why can't we see that? Because they tore it down. They tore it down. That's Buddy. So that said, let's continue, or let's pray for the family, all of them, that justice will be had, and that I hope the AG's office gets involved personally. Somebody with a lot more experience in court trials, homicides, death penalty cases, that they come into this circle, and that they either A, can guide it, and guide it, correctly, or B, take it on. But that's up to the Latah County, district attorney's office to turn it over, right? That's up to them. I just hope that their pride doesn't continue to stay in the way, and that the feelings of the University of Idaho get set aside, and that Scott Green realizes what type of challenges they caused, even in his book in the chapter. And what's ironic is the judge writes around it and says there's only one book, and I was referring to Blum's book, I assume. It definitely wasn't about Scott Green's book. The guy across the street, for lack of a better term. Let me fix you, Your Honor. It was 2 books. 2 books. And you complain about, or the defense complained about Nancy Grace? Are you kidding me? We need more Nancy Graces in the world, and we need more Vinnie Politons in the world. They do their job. God bless you all. Aloha.
Hard working every day, I'm stressed out 24/7, babe. No timeouts, wish we could fly away. You and I go to our favorite place. Oh yeah, make special memories together. I'll be your company now and forever. I say we fly away, you and me, go to our favorite place. Feeling the sun on my face in Hawaii. With you, Hawaii. With you, Hawaii. With you, Hawaii. I need a summer breeze, some fresh air to put my mind at ease. No cares. You wanna come with me? Me and you go to our favorite tree. Are you ready now? We jump on a plane now. We're taking away. Yeah, we're taking away. Don't hesitate now. We're taking away. Yeah, we're taking away. We'll never come down. We're going away. Yeah, we're going away. You and me. Feeling the sun on my face in a while.